Welcome to the Only Male Cruz Show, the podcast. I am the only male Cruz. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work. All right. Welcome to the Only Male Cruz Show, the podcast. I am the Only Male Cruz. Be sure to hit the like button, share, subscribe, replay game. You know what time it is. Leave a comment. You know I want to hear from you. Hey, y'all, today is my birthday. And I guess this is my birthday gift. I don't know. But y'all, this motion, Derrell's attorney has responded, okay? And I'm just going to say it right now. He is really trying to bring some heat. He's trying to bring some heat, y'all. The case in Chicago is going to be explosive. That's what I think. It's going to be explosive. Because it looks like Derrell's attorney is going to be a formidable contestant for Bonjean, but he's not. He can't bring no smoke on Bonjean. No, that's I stand on that one. So this man responded quickly, and that's very interesting. But I guess he's not really part of the government, so I guess it's probably easy. Let me do a quick shout out to the people in the chat. Thank you so much, y'all, for pulling up. I appreciate y'all. Like I said, hit the like button, subscribe if you haven't already, and replay gang, leave a comment. Shout out Island Brown, Shrink and Sharon. Thank you. Aretha, Jensen, Tiffany only, please. Thank you, Tiffany. Appreciate you, girl. Let's see. Shrink and Sharon, Pink Unicorn in the house. What's T, Pink Unicorn? Thanks for pulling up. Bree Edwards. Veronica Wilson. Yes, indeed. Busy Bee. Thank you. Y'all, thanks for the birthday wishes. I appreciate that. I appreciate y'all so much. And Carla McWilliams. Indeed. Okay, so I'm not going to keep y'all. I ain't going to hold you long. But we're going to get into this right here. And I'm sure I'm not the only one that's going to be covering it, but we here now. So let's get into it. All right. So the motion came in a couple hours ago from Derrell's attorney. And hold on, y'all. I'll be forgetting to take this thing off. But does it really matter since I don't be having my camera on? But anyway. All right. Defendant McDavid's response regarding motion to sever. So now comes the defendant, Derrell McDavid, through his attorneys. Mr. McDavid files this response to co-defendant Robert Kelly's May 16th motion to sever, not for the purpose of opposing severance, an issue on which Mr. McDavid takes no position, but for the purpose of correcting abject and unsupported falsehoods which have been recklessly foisted upon this court by counsel for Mr. Kelly in an apparent effort to circumvent this court's denial of her motion to continue. So he's coming out the gate throwing shade on Bonjean. But we know she has tough skin, and we know this. She's probably sitting back laughing at this one. All right. It's one thing to believe you deserve a continuance and disagree with the decision to deny it. That happens to all trial attorneys. It's even understandable for any attorney to be annoyed at the denial of a continuance and those who oppose it. But it is another thing altogether to manufacture the need for severance from a patchwork of bare allegations that recklessly impugn the integrity of respected members of the bar and falsely malign a co-defendant while presenting not a shred of actual evidence that supports these sweeping contentions that are made with neither tact nor tether to reality. Don't try to come for Bonjean, but you got some writing skills. I ain't mad at you. You got some nice little writing skills. I see you. See, but Bonjean can match you on that. Anyway, Derrell's attorney goes on further to say even a superficial examination of the actual evidence in this case makes plain that Mr. Kelly's baseless allegations against Edward Jensen, and by extension, Mr. Glossman and Mr. McDavid, are without merit. Even a cursory understanding of the evidence suggests that anyone making the allegations set forth in the motion to sever is either woefully uninformed or purposely mendacious, i.e., not telling the truth, lying. Mr. McDavid emphatically disagrees with the arguments made in paragraphs 18 through 30 of Mr. Kelly's motion, which we went over that yesterday, and I'll pull it up later. Mr. Kelly alleges that the late Edward Jensen engaged in misconduct or perhaps criminal actions while preparing for Mr. Kelly's 2002 trial in Cook County. Further, Mr. Kelly argues that as a result, Mr. Glossman, who was not hired by Mr. Jensen until long after Mr. Kelly's acquittal, is conflicted from representing Derrell on a case brought a decade thereafter. The undersigned are concerned that Mr. Kelly's motion could somehow be construed as a basis for disqualifying Mr. Glossman and thereby depriving Derrell of his Sixth Amendment right to counsel of choice. Mr. McDavid does not take that matter lightly. So Derrell got some rights, and he wants to exercise his rights, but he only has a curfew, and he's out on bail. Shout out to Prospective Me. T-girl, yeah. So he wants his rights. I got you. We got you, Derrell. You want your rights. The rules do not permit, and the Sixth Amendment does not allow, any finding of conflict on the part of Mr. Glossman in this instance, nor will Mr. Glossman's former employment with Mr. Jensen affect the instant trial in any respect whatsoever. Mr. Glossman was just entering high school when Mr. Jensen was hired by Mr. Kelly in 2002 and was an undergraduate at the time that Jensen's representation ended in 2008. Mr. Glossman took no part in Mr. Kelly's trial or the preparation thereof. He has absolutely no information, confidential or otherwise, relating to that trial, other than what he's seen in the discovery, in the instant case, and what is publicly available to anyone with an internet connection and the ability to use Google. See, there you go, trying to throw some shade. But Bonjean is better at it. Yeah, she gonna get you. It was not until years after Mr. Jensen's representation of Mr. Kelly that Mr. Glossman was ever approached about representing anyone related to this investigation. He was ultimately engaged by only Mr. McDavid. So, timeline in Chicago Sun-Times interview. Mr. Kelly was indicted in state court in 2002. He hired Mr. Jensen and his firm to represent him on that matter. The case was tried and Mr. Kelly was acquitted in 2008. And Mr. Kelly notes in his severance motion, according to the government, Individual A, who worked with Mr. Kelly's legal team, allegedly agreed to pay money to victims and witnesses and others to ensure that they did not cooperate with the law enforcement. Individual A also allegedly arranged for Individual B to be paid hundreds of thousands of dollars for obtaining and returning videotapes that depicted Kelly having sexual conduct with a minor. According to investigative reports, the conspiracies charged in counts 5 and 6 of the indictment occurred in part in the law offices of Ed Jensen, and that the completed crime of receiving child pornography, as alleged in counts 7 and 8 of the indictment, took place in Jensen's office. So that is what Bonjean had put in her motion. So, and this is Derrell's attorney addressing that specifically. He says, Mr. Glossman does not know individual A. He has never spoken with individual A outside of the discovery in this case. Mr. Glossman has no special knowledge about the relationship between Mr. Jensen and individual A. As the indictment alleges, these acts, which Derrell will contest robustly at trial, took place between 2001 and 2008. The only specific acts charged in counts 5 and 6, to which Mr. Kelly can possibly be referring, took place in 2007 and 2008. Count 7 concerns allegations that occurred between 2001 and 2002. Count 8 occurred in 2007. Mr. Glossman was hired as a law clerk for another attorney working in Mr. Jensen's office in 2012. He started working directly for Mr. Jensen in June 2013, again as a law clerk. Mr. Glossman received his law license in May 2014 and continued working for Mr. Jensen as an associate until he closed his office in November of 2017. After Mr. Jensen's law office closed, he employed Mr. Glossman periodically for the first half of 2018 to finalize some outstanding matters on behalf of some dozen or so clients. Now, I get what they're saying, but there's so much drama going on and shenanigans, like we said yesterday, in this case, that I'm hard-pressed to believe that this man wasn't on a slow day going through some old cases, because wouldn't you? And you got the law license to do it? I would. I'd have been all up in this landmark, even though it's not really a landmark, but I'd been all up through this R. Kelly case, because I'd be trying to figure out, damn, how did he win that for Kels? If that's, how did he win it or how did he lose it? But I would be dipping, and I'd have full right to do it. So anyway, Mr. Glossman had nothing to do with any representation of Mr. Kelly at the trial in the underlying state matter, for which he was acquitted well before Mr. Glossman even became a lawyer. The remainder of Mr. Kelly's claim is a disingenuous attempt to stretch out the length of Mr. Jensen's attorney-client relationship with Mr. Kelly. It relies exclusively on an interview that the late Mr. Jensen gave to the Chicago Sun-Times in 2019. And, Infamous Sylvia was on here yesterday, and she really broke that down as it relates to what the guy said. He said that, Sylvie said that the Sun came out later and said, his father was ill and he didn't mean what he said, and this, that, and 2/3. Nevertheless, it was put in print. But let's hear what Derrell's attorney says about this. He says, counsel's reliance on this interview and her attacks on Mr. Jensen are, quite frankly, disingenuous, insulting, and perhaps worse, pointless. As the court is aware, and as stated in the interview, Mr. Jensen was, at the time, suffering from the latter stages of terminal cancer. What the article omits is that not only was Mr. Jensen heavily medicated at the time of the interview, but that he was rushed to the hospital shortly after the interview took place, and that the interviewer only entered Mr. Jensen's home through false pretenses. Okay. In short, relying solely on the manipulative interview of a dying man who was suffering through terminal cancer and the medications that treat it is hardly the portrait of a thoughtful pursuit of truth. Don't use that phrase. The only person that should use the phrase pursuit of truth is Jennifer Bonjean and them. And you're going to come up here talking about the pursuit of truth. Anyway, let me stay focused, Mel. Many aspects of that interview were problematic, to say the least. From an ethics and client confidentiality standpoint, nonetheless, nothing about these statements, imprudently given by a dying man, limit Mr. Glausman's representation in this case. Mr. Jensen did not consult with Mr. Glausman about the interview, nor does Mr. Glausman have any special knowledge as to why Mr. Jensen made the statements therein, or indeed what those statements mean. Okay, y'all, please somebody put in the chat, do y'all believe all this so far? Real talk. Do y'all believe this? Was the man up under a rock this whole time? Shout out to Anthony Clay. So why is he mad at Jennifer Bonjean? He should be mad at the reporter. She's just doing her job for her client. Come through. Perspective Me said yes. He said something to the effect that his dad had dementia and the reporter snuck in. Well, Perspective Me. Thanks for that. So you're saying that the reporter snuck in, and because the dad, I'm just going to say RIP. I don't know the man, but RIP and F cancer. But because the dad had dementia, he didn't know who he was talking to, and the reporter printed it anyway. Okay. Mm-hmm. Yeah. I ain't buying that one. Okay. So Mr. Kelly suggests that the interview proves that his attorney-client relationship with Mr. Jensen continued after his acquittal in state court, or for at least the next 10 years, probably much longer. Jensen and Kelly maintained an attorney-client relationship. That's what he's saying. Kels and them are alleging. The undersigned cannot figure out where Mr. Kelly's counsel is getting the word next from. It is certainly not in the article. If next, as used by Mr. Kelly's counsel, means after Mr. Kelly's acquittal, that would mean that the attorney-client relationship ended sometime in 2018, after Mr. Jensen's office was closed. That is obviously not so. Yet counsel for Mr. Kelly went even further, suggesting that the relationship probably went on much longer than 10 years after the acquittal. Mr. Jensen died in April of 2020. Presumably, counsel for Mr. Kelly would acknowledge that Mr. Jensen did not maintain attorney-client relationship with Mr. Kelly after his death. You trying to be shady, Derrell's lawyer? Does that sound like shade to y'all? It sounds like shade to me. But further, use of the word probably by Mr. Kelly's counsel is an odd choice. It seems that the best way for Mr. Kelly's current counsel to discover when Mr. Gleason ceased representing Mr. Kelly would be to ask her client. If she wanted to present any meaningful support for her allegations about Mr. Jensen's representation, she would do what the Seventh Circuit requires for someone making factual allegations in a motion in which they are the proponent. Provide supporting affidavit from the client, which asserts the claimed facts. This is the standard procedure for the party bringing the motion. Now, again, you see how they want to stick to they want to stick to the letter of the law when it comes to them benefiting from it. She should do this. She ought to do that. That's how they do it in the court of law. But y'all did I'd like to hear what he has to say about Jane Doe number 5's evidence and how that got in there. I would just like to hear his opinion, since he's such an advocate for the law and it being applied properly. Shout out to y'all. Hit the like button, y'all. Mr. Kelly knows very well that there was no further representation by Mr. Jensen following his acquittal. Instead, counsel grasps at a single ambiguous statement of a terminally ill and now deceased man. Mr. Kelly's motion for severance implies that based solely on that statement, and here's a statement he's referring to, I didn't facilitate him. He had already done what he'd done, Jensen said. I did facilitate in the sense I kept him out of trouble for 10 years. I was vetting his records. I listened to them. Which ones would make a judge mad? So Mr. Kelly's motion for severance implies that based solely on that statement, this court should somehow infer that Mr. Jensen and Mr. Kelly maintained an attorney-client relationship for a decade following Mr. Kelly's acquittal. Now, I'm going to ask y'all this here too. If you were R. Kelly and you went to this man for him to listen to your records before they were released so that the judge wouldn't have issue with it based on the nature of the lyrics. And do you think that all Kels did was go in there and say, listen to the song. Is it good? Yes or no? And the man said yes or no. And then Kel said, all right, I'll holler, and left. Come on now. You're not going to tell me they didn't have a little bit of conversation. Come on. I'm not buying that one. I'm just not buying it. This claim is made without any statement from Mr. Kelly that even hints that such a relationship existed. That inference is wholly unsupported by the interview and the inference that there was still attorney-client privilege. The interview does not come off as one where Mr. Jensen is contemporaneously examining records in an effort to precisely recount the time period of his attorney-client relationship with Mr. Kelly. Even if one were inclined to take 10 years as definitive and accurate statement as to the length of representation, that would mean that the attorney-client relationship ended in 2012. That is the same year that Mr. Glausman was first employed by another attorney in Mr. Jensen's office as a law clerk. And have y'all peeped how they trying to do like this arm's length transaction? Mr. Jensen didn't hire Derrell's attorney. It was an attorney in Mr. Jensen's office that hired Derrell's attorney. Y'all not going to tell me y'all didn't go through files. And a law clerk? I know they told you to access something. Don't do it. Don't do me. All right. At the time, there is no indication that the other attorney, and to an even lesser extent his law clerk, had any dealings with Mr. Kelly. Indeed, there does not appear to have been any reason for Mr. Jensen to have any dealings with Mr. Kelly during this time. Hence, without some supporting statement from Mr. Kelly, the representation of this allegation is both troubling and transparent. It's troubling because without any supporting statement from Kelly, these allegations can only be described as reckless and ill-considered. It is transparent because it is an obvious attempt to manipulate a way around this court's ruling regarding the trial date in this case. Mr. Glausman has no idea what Mr. Jensen meant by vetting in the approved quoted passage, nor does Mr. Glausman have any independent knowledge of how long Mr. Kelly and Mr. Jensen's attorney-client relationship lasted. Mr. Glausman does not recall having any contact with or observing anyone in Mr. Jensen's office having contact with Mr. Kelly during his time there. Mr. Glausman does not know and has never spoken with individual A. Furthermore, it seems entirely likely. Didn't he just say in a couple of pages before this that use of the word likely is problematic for him? Okay. Furthermore, it seems entirely likely that Mr. Jensen, who again was in the final stages of terminal cancer, was referring to the time when Mr. Kelly's state charges were pending. For example, in discussing what he vetted, Mr. Jensen referenced the song Ignition. I was riding in the car, listening to a song, and said, "Are you crazy? This is all I need." He rewrote it. Ignition, Jensen said. It's a song related to a guy driving around in a car with his girlfriend. It was originally a high school instructor in a class teaching people how to drive a car. I changed the words. Now, for somebody who they're claiming to have dementia and terminal cancer, RIP, F cancer. Um, you know, you're sure wanting us to hold this specific statement about the song Ignition and how he heard it, the first version, and his, response to hearing it, and then he changed it. I mean, that's a lot of information, a lot of specific information, don't y'all think? And if you got to mention, you're like, yeah, and then I told him, tie your shoe. And then I said, so which one is it? And I'm not trying to speak ill of the dead, Lord have mercy. But it's the way that they're writing this up to make it seem as though we can't rely on anything Mr. Jensen said when it looks like attorney-client privilege is questionable. But you want us to rely on us being able to rely on what he said when he's specific about how mundane or how minute or how unimportant vetting means, which is what he said in the article. You can't have it both ways, baby. Mr. Jensen's use of the word records seems to be referencing not business records, but music records. By vetting Mr. Jensen seems to mean listening to his music for anything that might be used against him in court. According to Google, Ignition was released by Mr. Kelly in 2002. Thus, the context does not suggest any vetting that went on following the acquittal. In Mr. Kelly's attempt to stretch out the length of his attorney-client relationship with Mr. Jensen to get closer to Mr. Glossman's date of hire, he relies heavily on an imprudent interview given by a gravely ill lawyer, telling stories about a 6-year-long case that ended over a decade before. Once again, hardly the portrait of the thoughtful pursuit of truth. Okay. Mr. Glossman has no confidential information regarding Mr. Kelly. Mr. Kelly argues that in his severance motion, that the attorney-client relationship between Kells and Jensen was imputed to Glossman, who was Jensen's associate. The motion further states that based on the foregoing, any privileged information conveyed by Kelly to his prior attorney, Edward Jensen, was also received by Jensen's associate, Mr. Glossman, either actually or constructively. That is simply not how the law works in this area at all. This is a case involving successive representation by a former firm. It is governed by Rule 19 of the Illinois Rules of Professional Ethics, Illinois Rule 19B. It is not unique or different from the model rules in any meaningful ways. I'm not going to read Rule 19, okay? I ain't going to read it. In case it is not already clear from the above, Mr. Glossman has no confidential privileged information regarding Mr. Kelly's state case, other than what has been discovered as part of the instant indictment. He has never spoken to Mr. Kelly, nor does any statement made by Mr. Jensen in the 2019 interview provide anything close to a good faith basis for believing as much. As comments to Rule 19 make clear, that is exactly the type of situation where Mr. Glossman is absolutely permitted to represent Mr. McDavid, aka Derrell, because no conflict acknowledged under the law exists. Second, the rule should not be so broadly cast as to preclude other persons from having reasonable choice of legal counsel. Third, the rule should not unreasonably hamper lawyers from forming new associations and taking on new clients after having left a previous association. If the concept of imputation were applied with unqualified rigor, the result would be radical curtailment of the opportunity of lawyers to move from one practice setting to another, and of the opportunity of clients to change counsel. Paragraph B operates to disqualify the lawyer only when the lawyer involved has actual knowledge of information protected by Rules 16 and 19C. Thus, if a lawyer, while with one firm, acquired no knowledge or information relating to a particular client of the firm, and that lawyer later joined another firm, neither the lawyer individually nor the second firm is disqualified from representing another client in the same or related matter, even though the interests of the two clients conflict. Why didn't you just say that in the beginning? So they want to get all the way down to the letter of the law. He's saying that there's not a problem. According to the Illinois Rule 19, if the attorney who is representing a client has previously worked for another office, it's not an issue ultimately, and that's questionable. And, my question is this. What was the relationship between Kels and Derrell when Kels was dealing with Jensen? Wasn't Derrell on the scene at that time? And Perspective Me, if you're still in the chat, I'm sure you know. And if he was, then that means by way of Kels, Derrell has some information. Because if Derrell was writing all the checks, and I'm sure he wrote that check out to pay Jensen. So you're not just, you are not arm's length transaction in this thing. You know what I'm saying? You've tried it. You're not arm's length. You got details. And you want us to believe that through all of this, that you didn't say nothing. You didn't say anything, Derrell. But maybe you didn't. It's all alleged. The views and opinions expressed in this show, they're just opinions, y'all. All right. So, Mr. Kelly asserts that in the years following Kelly's acquittal, Kelly and Jensen maintained an attorney-client relationship. If that is true, counsel should be able to do better than making an allegation that seems to be based exclusively on a far-flung extrapolation from an already ambiguous statement in an interview given under what was obviously a hampered mental state. But you want us to be clear about the differentiation that Jensen made about the song Ignition. So when was his mental state hampered? Come on now, Mr. Kelly was simply not a client of Mr. Jensen during Glausman's employ. The most consternating aspect of the allegations in Mr. Kelly's motion to sever is that all of it serves absolutely no purpose. Even if the Jensen-Kelly attorney-client relationship could be, in some de minimis way, stretched into a time when Mr. Glausman worked for Mr. Glassman, Rule 19B still applies. And that is what I read earlier about attorneys being able to switch different practices. And based on what Bonjean put in her motion, if the judge were to grant the motion that, that would hamper anyone from switching law offices or choosing the attorney of their choice. It says, Rule 19B still applies. Mr. Glausman did not have any privileged conversations with Mr. Kelly, nor did he obtain or have any reason to obtain confidential information. If one is going to attack someone's integrity, it should at least be for a reason. Yet legally, Mr. Glausman has no conflict. Hence, nothing about him or Mr. Jensen could serve as the basis for severance. Mr. Glausman does not have any special knowledge that could put Mr. Kelly at a disadvantage. That is the simple reality of the law as it applies to this situation. All of these claims about Mr. Jensen serve no purpose under the law. As for counsel, Derrell told Kel's lawyer, Derrell is not going to present his defense to anyone prior to the beginning of trial. He is not required to, and would be foolish for doing so. Nonetheless, he will say that which the evidence plainly demonstrates to anybody or anyone who actually looks at it, Derrell never took a dollar from Robert Kelly without authorization and justification. As with the claims regarding Mr. Jensen and Mr. Glausman's counsel for Mr. Kelly uses conjecture, bare allegation, and conclusory statements to stand in for that which is missing in the motion to sever. Citation to any actual exhibits or proven facts about Derrell's handling of his client's finances. Let me hit the comments real quick. So what it sounds like what he's saying here, if Derrell can say, we have a right not to tell you how we're going to present our case, why does Bonjean and Kells have to tell you exactly how their position is about the finances? Because in the motion yesterday, Bonjean said, and don't make me pull this up and start flipping the pages, where she alluded to the man had control over Kells' finances for 15 years and stole from him. Let me check out these comments real quick. Purple Couch, shout out. She said, I do not believe that in any way he has information. I do not care what they are saying in that answer. Ooh, lies. Indeed. Bree said, they are trying to be slick. Yeah, they're trying to be slick. They're gonna be all right though. Now he's lying if he wasn't before. Never took a dollar. My jazz. Ain't that it? Kells ain't gave McDavid permission to spend his money on me. Ooh. Come on and say it. Say that. Shout out to Taniqua McKay. So let me find this. Where was I? Right here. It's not hard to imagine. Let me just get it right here. Counsel for Mr. Kelly has indicated a difficulty in getting through all of the discovery. Perhaps that is the explanation for these claims about Derrell. If not, it's hard to imagine from whence these assertions find their genesis. Mr. Kelly's motion ignores detailed audits that were conducted regarding all of Mr. Kelly's accounts and Derrell's handling of them. Who conducted the audits? Okay. Was it Derrell's office with his CPA self? Did he conduct those audits, or did someone in his office conduct those audits? And you want us to rely on that? Is that what you're saying? I'm just asking. Nor does it reference the independent lawyers who represented Kells regarding his contractual relationship with Mr. McDavid and counseled him about the contract's terms and the settlement of the subsequent lawsuit. And I believe there he's referring to that lawsuit that we talked about yesterday, where, and I had that slide up there yesterday from TMZ, where it was supposed to have been some $1 million, $1.3 million, and Derrell sued Kells, talking about he better pay me my money. He was supposed to pay me $330 something and then $10,000 a month or something like that. Is that the lawsuit you're talking about, where Kells said you manipulated him? I'm just wondering. When an individual has his own independent legal team examining a contract's terms at the time of execution and negotiating a settlement upon its subsequent breach, it is rather hard to divine a sense in which the individual was somehow tricked by the contract process. Well, I mean, is it really that hard to be fooled if during the settlement, the man who tricked me also says, hey, why don't you use this guy? If you don't trust me, check out old Joe down the street. He's cool. He'll give you the truth, Kells. Come on, man. Come on. Bonjean is not going to stand for this, I believe. If Mr. Kelly had evidence contradicting this common sense reality, he would no doubt present it. The fact that he does not speaks volumes. Derrell will not take the time to dignify. Y'all hear that white privilege phrase going on? Derrell will not take the time to dignify each of Mr. Kelly's allegations, which are made without citation to any exhibit or statement from Mr. Kelly with a response. He's basically saying, either show me what you're talking about, because I'm not going to dignify what you're saying to me, Kels, or what you're saying about me. Okay. Put your card in your pocket, Derrell. What he will do is remind the court of the simple proposition that the proponent of a severance motion bears the burden of proving the allegation alleged to justify severance. This is not a controversial point of law. Yet, when it comes to proof supporting any of the allegations about Derrell, Kel's motion cites none. This is because reference to actual evidence will not possibly aid Kel's cause in contending some sort of theft or bad faith by Derrell. Now, referencing actual evidence about, which was in the motion yesterday, about you stealing money from Kel's, will give you time, maybe allegedly, to tighten up that situation, to turn it around. All of a sudden, ooh, I found these documents. They was over there up under the bridge. Okay, so will there be antagonistic defenses? Derrell does not have any reason to believe there should be, but it is always possible. Should there be a severance? Maybe. Nonetheless, one cannot manufacture a basis for such a severance by making reckless accusations in the absence of actual proof. The law does not allow that. Thankfully so. Conclusion? Derrell does not object to Mr. Kelly's motion to sever. However, severance should not be granted, nor should any other action be taken by this court based on unsupported and unproven allegations. Come on, y'all. Y'all know what this is, don't you? Y'all know what it is. Will there be antagonistic defenses? Shouldn't be, but it's possible. Should there be a severance? It could be, but we don't want you to grant it. Come on. So essentially, Derrell's attorney, Derrell's team, they want the law to be applied fairly and justly in their behalf. That's what they want. Nope, see, the law says this and the law says that. And they want to be able to say, we're not going to put none of our evidence out there. Why? We're not going to dignify any of these with a response. And if you guys are going to make these statements, then you prove it before court. Why? You're not putting up, defend yourself. So, okay. I'm going to go through these comments. I want to see what y'all want to say. Somebody say, drop the link if you want to come up here and chop it up. And we can. So, Alvina said, Bonjean is not just talking. Bonjean is not just talking. She already had the proof. And by speaking on it, she letting them know the smoke is around the corner. Go on and say that. Well, then why is it that Kel's, Alvira, then why is it that Kel's owe so much to the IRS? If Derrell was taking care of Kel's business, but Derrell has a restaurant in an upscale area of Chicago. But you want to talk about, and it's crazy that they offer the, he can go ahead and he had an attorney. He had somebody go through the contract with him. Come on now. Y'all already know. Bonjean is sitting back laughing. I really do believe. I'm trying to check these comments, y'all, because I appreciate y'all patience. Y'all hit the like button, share, subscribe. If you haven't already, replay gang. You know what to do. Leave a comment because you know I want to hear from you. Let me run through these comments real quick. Taniqua McKay, you said it right. All right, Matt Oliver said, Bonjean is exposing them all. Ain't that the truth, Matt? She's making them go ahead and put up. And if you notice, Elizabeth Geddes, our favorite New York state attorney, assistant state attorney, she didn't have to go through all this. Because Bonjean went on the case at that time. That's all right. That's all right. Let me see. Oh, wait a minute. So now he is lying if he wasn't before, never took a dollar. I don't know, y'all. I don't know. But now what I'm not clear on is if Bonjean is going to have the opportunity to respond to this motion, or if, June Brown's attorney's going to jump on deck and say a little something. We don't know, but it's getting hot in here. And I put on my community tab about our favorite Chicago newspaper reporter. I think it's Jason Meisner. He's talking about, he put a tweet out there talking about it's heating up in the Kells case. It's heating up, but not between the attorneys. It's heating up between the defendants. I responded and I said, quit showing Kells in that orange jumpsuit. You ain't got to do all that. Stop it. You got other choices. There's other pictures to choose from. So I don't know, y'all. Listen, I ain't seen it nowhere in the comments that y'all said, hey, Mel, drop the link because I'm trying to pull up. I got something to say. And I ain't going to keep you long. Don't want to keep you long unless you want to. I do want to say this, though, y'all. If y'all have an opportunity, please download the Station Head because, I would like for us to be able to go over to Station Head to have a more in-depth conversation about this Kells thing without turning these YouTube videos into, 3-4 hour lives type thing. But so if you can download the app, or if you have the app, let me know. But pretty soon, maybe even before the Chicago trial starts, I want us to be able to go over there and, have some panel discussions. Plus, put some of Kells' music on deck as well. Aretha said if they didn't have anything to hide, why they didn't just give her, why didn't they just go on and give Bonjean the 90 days? Exactly. But I will tell you, Derrell's attorney is one hell of a writer. He's got great writing skills. I ain't mad at him. And, he got a little zest to him. I ain't mad at him. The bigger issue, though, is he's not better than Bonjean. I believe Bonjean eats, breathes, and sleeps this thing, okay? She's made for this, built for this. So that's it, y'all. That is the podcast. Be sure to like, share, subscribe, replay gang. You know what time it is. Leave a comment because I want to hear from you. And until next time, we will see ya when we see ya. Welcome to the Only Mel Cruz Show, the podcast. I am the only Mel Cruz. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work.